Welcome to this August 24th meeting of the Charlotte City Council Budget and Effectiveness Committee. My name is Ed Driggs. I'm the committee chair. And would others like to introduce themselves? Committee members?
Good morning, Dimple Ajmera, committee member.
Good morning, Renee Johnson, District 4 committee member.
Good morning. I understand that Mr. Graham and Mayor Pro Tem Issa will not be with us today, but we have a quorum, so we're going to proceed with the meeting. Would you like to talk about the agenda?
Yes, sir. So first of all, I'm Brent Cagle, Assistant City Manager.
Sorry, we need to do the rest of the introductions.
Yeah. I am Brent Cagle, Assistant City Manager. This is my first meeting assuming responsibilities to support or provide staff support, so I'm excited about it. But rest assured, we have Mr. Bergman and Ms. Smith with us in case we have any questions. But again, I'm excited to be here.
Great. Why don't we continue with the introductions?
Good morning, Lena James, Deputy City Attorney.
Good morning, Willie Ratchford, Charlotte-Mecklenburg Community Relations Committee.
Donata Jackson, Office of Constituent Services.
Tina Adams, Internal Audit.
Greg McDowell, City Auditor.
Marie Harris, Strategy and Budget.
Ryan Bergman, Budget Office.
Teresa Smith, Finance.
Tell I'm a little out of practice after the break and everything else. Okay, so our agenda.
Yes, sir. So we have 3 items on the agenda today. The first will be the non-discrimination ordinance or NDO enforcement presentation from Mr. Ratchford. The second will be internal audit update and briefing from Mr. McDowell. And the third is virtual meetings, a revisiting of the virtual meetings topic that the committee has had in the past with Ms. James and possibly Mr. Baker.
Thank you. Before we kick off on the NDO with Willie, I just want to mention that we are talking about this because after the adoption of the expansion of our NDO by City Council not too long ago, the mayor instructed this committee to consider the implementation and enforcement processes around, in particular, the new protected classes and the expansion to include employment. So, Willie, would you like to set us up for that conversation?
Absolutely. Let me start off, Chairman Griggs, by thanking you all for this opportunity to talk about the work and the role of the Community Relations Committee in administering. Let me thank you all for this opportunity to talk about the role of the Community Relations Committee and staff and the members of the Community Relations Committee in administering the Public Accommodations Ordinance, as well as those new protected classes that were decided on by City Council at its August 9th meeting a couple of weeks ago. What I'm going to do is to quickly talk about what the council action was about, and that will just take a few seconds. We then talk about an overview of the work of the Community Relations Committee, CRC has been around for a long time, and I've worked here 41 years, and I'm constantly getting questions about what is it that CRC does. And I'm hopefully folk will have a better understanding after hearing some of the information on the CRC today. We will then talk about the public accommodations ordinance and the new protected classes that were added as a result of the non-discrimination ordinance or the amendments to the current public accommodations ordinance. We'll talk about how we will actually investigate complaints that are brought under the NDO as it relates to public accommodations, including what jurisdiction looks like, what it means to receive a complaint, and the investigative process for complaints under public accommodations. We will briefly mention passenger vehicles for hire and commercial non-discriminatory procurement. Those are two items that the Community Relations Committee will not administer under the ordinance, and we'll talk a little more about that a little later. And then we will talk about the employment portion of the NDO and the way that the Community Relations Committee proposes to actually investigate employment complaints under the NDO. As you can see on the slide up here, Council took action back on August the 9th to amend the current public accommodations ordinance to include 7 new protected classes, which include familiar status, which means that you have children in your custody who are 18 years of age or younger, sexual orientation, gender identity, gender expression, veteran status, pregnancy, and natural hairstyle as classes that will be protected against discrimination. They also, in this ordinance, this applies to the city code governing public accommodations, passenger vehicles for hire, and commercial non-discrimination procurement, which will become effective the 1st of October, as I understand it. And then the employment protections will not become effective until January the 1st of 2022, which is appropriate because it will take some time to get prepared to receive and investigate discrimination complaints of employment with the NDO. And the employment protections will include all employers in the community. If you are aware of the work of the Equal Employment Opportunity Commission and Title VII of the 1964 Civil Rights Act, which governs employment discrimination, employers with less than 15 employees are actually exempt from federal law. However, the city's ordinance covers all persons regardless of the number of employees that you might have. Next slide, please. Actually, we can go to the next slide after that. We're going to quickly talk about the work of the Community Relations Committee. The Community Relations Committee has been in existence since 1961, and we work to represent an inclusive community. We have successfully built relationships and promoted community harmony here in Charlotte-Mecklenburg. We have a 45-member board, half of whom are appointed by City Council, the other half are appointed by the County Commission, and we have 17 staff members. And we also work to ensure fairness for all and remove barriers that impede this community from living in harmony. Next slide. The powers of the Community Relations Committee are actually derived from the city's Human Relations Ordinance, which was initially passed back in 1968. And under that ordinance, we have the power to maintain an office in the County of Mecklenburg, appoint an executive director and other necessary staff. We can contract and cooperate with individuals, including state and local government. We can accept public grants or private gifts or other payments. We study problems in the area of human and community relations. We promote the quality of opportunity for all citizens. We also promote understanding, respect, and goodwill among all citizens. We provide channels of communication among various racial, religious, and ethnic groups in the county. And we render an annual report to both the City Council and to the County Commission. And we, from time to time, will make recommendations to the elected bodies to eliminate or reduce discrimination with respect to race, color, religion, sex, or national origin. And actually, that will now expand to include the new protected classes, but these were the original protected classes dating back to 1968. Next slide, please. As I mentioned, we have a 45-member board, and many people ask the question, well, how do you manage a 45-member board? Well, the best way to do that is through subcommittees, and so we have 7 subcommittees that are responsible for carrying out the responsibilities of the community relations, as I've just mentioned. We have a Martin Luther King Jr. Birthday Celebration Committee. We have a communications subcommittee, an education and young leaders, because we're concerned about a lot of the things that are happening with young people in this community, including what appears to be an inability to manage conflict and having simple situations that end up escalating to violence. We have an intercultural relations subcommittee. When the Community Relations Committee started a long time ago, race relations in this community was simply black folk and white folk. Well, it is much bigger than that now, so intercultural relations is very appropriate. We have a Police Community Relations Awards subcommittee, as well as a Police Community Relations Engagement subcommittee. It is the belief of community relations that public safety is not just a job of police officers. It is the job of police officers and citizens actually working together. And so we administer these 2 programs to improve relationships between police officers and citizens, especially minority citizens. And finally, we have a Programs and Speakers Subcommittee. As we think about the various issues that may be going on related to race relations in this community, we like to bring in speakers who talk about specific topics that are germane to the work of the Community Relations Committee. Next slide, please. As I mentioned, we have 17 staff people, and this staff, their work is divided up into 4 divisions. We have an administrative division. Most of you may be aware that the city's ADA work actually runs through the Community Relations Committee staff, and Terry Bradley, who is the city's ADA coordinator, is also the deputy director of the Community Relations Committee. We have a Community Affairs Subcommittee whose primary responsibility is to coordinate and plan community dialogues around tough and difficult issues in the community, especially as it relates to race and those things that we don't like to talk about from time to time. We have a dispute settlement division, which acts as an alternative to courts, and we have actually been given a courtroom over in the court system, and we have staff and members of the Community Relations Committee who meet there every Monday. And as cases are going on in the various courtrooms, a judge may come across a case that he or she thinks might be more appropriate with mediation as opposed to going through the court process. So they will allow those persons to come down to our courtroom, and if they're successful in resolving their conflict, then the criminal charges or the charges against the 2 will actually be dropped. So it's a really successful program. And then we also have some law enforcement responsibility, and so we have a fair housing and public accommodations division. In addition to enforcing the City of Charlotte's fair housing law, we also enforce Mecklenburg County's fair housing law, which prohibits housing discrimination in the unincorporated areas of Mecklenburg County. And then, of course, there's the public accommodations ordinance that we have been administering since 1968. If you look at this next slide, it talks about the 5 protected classes that have been in the ordinance up until August the 9th, and they were race, sex, color, religion, and national origin. And with regards to investigating complaints on these bases, we have over 50 years of experience.
Could I just interject a quick question here?
Sure.
Could you talk about what public accommodations are, what that means? That's not
Public
necessarily
accommodation-
obvious to people.
Absolutely. Public accommodations are those entities in the city that are open for public service, including movie theaters, restaurants,
Retail establishments?
retail establishments,
Right.
anything, any groups that allows the public to actually come in to transact business is considered to be a public accommodation.
Thank you. Thanks.
Access to city buildings or county building is a public accommodation.
Right. Good, thank you.
Thank you. Great question. If we can go to the next slide. You will see, in addition to the 5 original protected classes, and I think you may, go back one slide, please. In addition to the original 5 protected classes, we have listed here the 7 new protected classes as a result of City Council approving the non-discrimination ordinance. And so our sense is that when it comes to investigating complaints where folk are alleging violations of the non-discrimination ordinance, we will investigate those in the same way that we have investigated the 5 original protected classes since dating back to 1968. We're not going to make that many changes, and I'm going to talk about, starting with this next slide, the way that we actually do that. Have had several folk to approach me to ask me, how do we prevent people from actually filing frivolous complaints? And that is a fair question, and so one of the things that our investigators will do is whenever we receive an allegation of a violation of the Public Accommodations Ordinance or the Non-Discrimination Ordinance, the very first thing that we will do is ask questions which will allow us to determine if that complaint is jurisdictional or not. And a complaint is jurisdictional if the complainant or the person who is making the allegation has standing to file. The respondent is covered under the ordinance. So, for instance, Mr. Griggs had asked a question about a public accommodation. If you own a private club, then you are exempt from the ordinance. And so if someone came to us and wanted to file a complaint against a private club, then that complaint would not be jurisdictional, and we would not accept it and investigate it. The public accommodation related transaction is actually covered under the ordinance, and the ordinance will let you know which transactions are actually covered. The subject matter is covered under the ordinance, and the complaint has to be timely filed. We're looking at a 180-day statute of limitations, so if you have an incident and you feel that you have your rights have been violated under the ordinance, you have 180 days to actually file that complaint. The only way that can be extended is if you have multiple transactions where you are alleging that violation, and so the discrimination is considered to be sustaining and ongoing, and so the very last date that it happens, the 180 days starts at that date. Yes.
Quick question on that. You say jurisdictional. If somebody lives in Matthews and works in Charlotte and feels that they've been discriminated against in their workplace, would they have standing in Charlotte?
If the workplace is in Charlotte.
The workplace, so what controls in that situation is where the discrimination is occurring,
of the
right?
workplace, yes.
All right, thank
Yes.
you.
Next slide, please. I want to just quickly go through how we will actually receive a public accommodations complaint, and we actually have a complaint form that we to receive information regarding an individual's allegations. And it starts off with an interview of that person where we ask for information on the complainant and any other agreed parties that may have been with them when they had their particular incident. We want to know exactly the alleged violation and why they feel that it occurred. What is the basis for it? Is it because of your race, your sex, because of your sexual orientation, your familial status, your veteran status? Why is it that you feel that you were a victim of discrimination in violation of the ordinance? We ask for the address and location where the alleged violation occurred. Again, related back to your question, Mr. Griggs, because if the place is located in Rock Hill, we're not going to go down to Rock Hill and investigate that. If it's here in Charlotte, we are authorized to actually investigate it. We want to know who the respondents are and their representatives, and we want contact information on them because we will have to contact them to actually start the investigation process. We also ask for a brief and concise statement of the facts regarding the alleged violation. Maybe a paragraph or two of them explaining exactly what happened and why they feel that they are a victim of discrimination under the non-discrimination ordinance. We ask for the most recent date of the alleged violation because of the statute of limitations. And we also would advise them that the alleged acts, if proven, may constitute a violation of the particular sections of the non-discrimination ordinance. And then we will have them to sign off on, and we will have a note. We actually want a notarized signature for the complainant, from the complainant. And we have 4 or 5 staff people who are notaries, and so we get the information notarized at the offices of the Community Relations Committee. Next slide. Once we have received all of the information and the director signs off on the complaint form of the complainant, we will draw up a letter of notification that we send to the respondent. And in that letter of notification, we will advise the respondent that a complaint has been received which names them as the respondent. We would also advise that the Community Relations Committee has authorization to receive, investigate, and seek to conciliate and mediate the complaint itself. We will advise that we will complete the process within 100 business days. However, exceptions can be made for a complex case which might take longer. Perhaps one of the most important things that we advise them of is that they have an opportunity to resolve the complaint through conciliation while the investigation is actually going on. So conciliation and investigation run concurrently but parallel, but they should not cross. If we advise someone that they can conciliate the complaint, and if we get the parties together and they conciliate the matter to the satisfaction of both parties, they would end up signing what we call a negotiated settlement agreement. And we would, at that point, stop the investigation and close it without a finding of fact because the matter has already been resolved between the two parties. In the letter of notification, we might request a written response and a position statement to the complaint. We might do a site visit if that's necessary to get a sense of where it happened and why it may have happened. We might even conduct a test where we get people and we give them a script which makes them the same people. The only variable would be their protected status, and we will send them out to the business to see how a black patron might be treated compared to a white patron, or how someone who is gay might be treated versus someone who is not gay. That gives us direct evidence that the discrimination may or may not have occurred. It really is. It really is, yes. We also interview the complainant's witnesses if they identify witnesses, and obviously the respondent might also have witnesses that they want us to interview, and we will review their witnesses also. After we get all of the information together, we will make what we call a determination. And the determination is that we believe a cause determination means that based upon our investigation, we believe that the ordinance has been violated. And a no cause means that we based upon that investigation, the evidence does not show that discrimination actually occurred. If it is no cause, then we close the case out at that point. If it is cause, then we're required to attempt conciliation again because we're always looking for ways to resolve the matter. If we're not successful with that conciliation, the respondent may appeal the cause finding to the conciliation division, which acts as a hearing panel. And that hearing panel will listen to a presentation from the CRC as to why they made their finding, and they will listen to the respondent and or their attorneys as to why they feel the CRC may have made the wrong determination. And the panel will either uphold the finding of the Community Relations Committee, or they will say, no, this was, you made the wrong decision and this is no cause. If they say no cause, then it stops at that point. If they concur with our finding, then we would one final time attempt conciliation. And if that conciliation is not successful, we would then refer the matter to the city attorney's office for appropriate action. Yes.
So, who are the conciliation division? What people are they?
The conciliation division will consist of 7 people who are members of the Community Relations Committee, and they will be appointed by the mayor according to the ordinance.
Right. And then you mentioned a referral to the city attorney's office. So, city attorney, what do you do with that?
Mr. Driggs, with all due respect, I believe Mr. Baker is on the line, so I'll defer to him to see if he wants to answer first but if not, happy to take it.
Good morning, everyone. Sorry, it took me a couple minutes to get on board. I have not received a complaint in the 2.5 years that I've been here. I would imagine that if there's a referral made to the attorney's office, I would review it with the staff, ask whatever questions are needed, and then take whatever appropriate action I feel under the circumstances is appropriate. Having not seen any of these before, and I don't know if Mr. Ratchford has ever referred a public accommodations complaint to the attorney's office. I don't want to box myself into what I will or won't do, other than I would make whatever actions I felt were necessary and appropriate based on the facts and circumstances of the complaint.
Thank you. So, Mr. Ratchford, have you referred to the city attorney in your long career
In
in
the
the past?
41 years that I have worked for the CRC, we have never referred a public accommodations complaint to the city attorney's office. We have always been able to resolve them through mediation or conciliation or a no-cause finding.
Okay, I just want to focus on this a little bit because our charge was, what is the enforcement, right? So if we reach, I guess a conclusion we can reach is that these things get worked out through the process that you described and have been every time up until now. Do you have any idea how many complaints you've processed? Like how many of them occur in a typical year?
Okay, that's a great question, but also a tricky question. So back in 1968, when the city of Charlotte enacted a public accommodations ordinance, you can imagine in the 60s there was a lot of violations of that particular ordinance just based upon the race relations of this community. As race relations have gotten better in the succeeding years, the number of complaints under the public accommodations ordinance have gone down dramatically. And well, on average, we may get 4 or 5 complaints a year right now. But that's based upon those 7 protected classes.
Right.
I mean,
But
I'm on the original
generally it's
5
about
protected
race, isn't
classes.
it? For the most part, it's about race mostly.
Mostly about race, yes.
Age? Do you get any age cases?
No, we haven't had any age cases that I'm aware of.
See, I don't get respect from the younger members of council, and I was thinking of starting an action about that. But, okay, so this is a question in my mind that we need to be able to answer. If there's a referral to the city attorney's office for appropriate action, what actions are available to the attorney at that point? So, as I understand it, the city of Charlotte is expressly excluded from being a party to a dispute like this, i.e., we have this ordinance, but that does not make us in any way legally a party. Is that right? Or Mr. Baker?
It really depends on how you look at it. As between the employee or the individual and the accommodation, I would agree, but we do have the authority to enforce our ordinances, and that's essentially what we would be doing if we went into court, similar to how we would enforce any of our other ordinances where we find that there has been a violation of the ordinance. You're probably most familiar with some of the code enforcement ordinances that we have through our housing code enforcement apparatus. So we would be enforcing the ordinance, not so much getting involved in the individual issues between the parties, although I think from their perspective it probably looks the same.
So the point is that our ordinance does have the force of law such that a court would enforce it. Like if we brought an action alleging a violation of our ordinance, they would treat that as a violation of law subject to judicial action of some kind.
Correct.
Right?
Correct. Yes.
So our answer to the question is it gets referred to the attorney. Other than initiating legal proceedings, what kind of actions would be available to the attorney? I mean, I think this is the kind of question that we're here to address. So we go through the process. Our hope is that, like every time in the past, it can be resolved within the scope of the steps you've described. But for good order's sake, I think we would need to be clear on what can happen as a result of a referral to the city attorney.
Yes, and what you often see is equitable relief. That is to get an injunction to prohibit the outfit from continuing to discriminate in their public accommodations, and that would be would have the force of a court order, which, if there was a further violation, could have the entity back in front of court on a violation of a court order complaint.
So to my colleagues on the call, this committee could take the position that the mechanisms we have in place now for our prior NDO are appropriate for the new protected classes, and that therefore there is no council action required specifically as a result of the expansion of the ordinance as it relates to public accommodations. And so that would be my position. I'm interested to know if Ms. Ajmera or Ms. Johnson, if you have any thoughts about that.
Yes, Mr. Drakes, I do. So thank you for all the fact-finding and the presentation. And it was very informative. First of all, it was,
If you
first
could,
of all, when I see...
Ms. Ajmera, if you could speak a little louder, I'm having a hard time. Just shout. There, yeah, that's good.
How about now?
Yeah, that sounds better.
Okay, great. So when I see all the complaints so far that's been resolved by our community relations department, I don't know what does that mean for us for future, especially for us moving forward with our new protected class. Yes, the data tells us that it's been working. So I want to give it a try, maybe for a couple of months before, and see what kind of complaints we get based on the new protected classes, and see if we need to implement additional measures than what is currently in place. But I wasn't aware that all the complaints were getting resolved by our community relations, and none of them have been referred to the city attorney so far. And that is certainly outstanding.
I think it would make good sense for us to recommend that we perhaps suggest that we use the existing procedures and that we revisit the question after 6 months or some period of time to see if anything comes up that indicates special treatment is needed. Would that be your suggestion?
Yes, that would be my suggestion. However, I would also like to have public feedback on this, because this is, I don't think we have had public forum on this specifically. So if we can also get feedback from some of our concerned residents who are advocating for stronger enforcement, I would like to hear their perspective as well, based on the data that we have seen from our staff.
So if we publicize the date on which council proposes to act on any recommendations we make, there would be an opportunity for speakers to sign up then, right?
Yes.
So all we have to
and
do is make sure that people know.
Absolutely, Mr. Drakes. And I think based on their feedback and what other cities have done, who knows, the council might decide to change direction. But at least we got to give them an opportunity to express concerns around our process.
Well, you were just a member of a protected class for most of the last year, so you could speak. All right, point well taken. So we'll think about making sure that we get some input and that we keep open the possibility of revisiting the actions that we take now in light of anything that our experience tells us in over an unspecified period of time. I mean, basically at any time, if we recognize that there is some sort of a gap because the new protected classes aren't the same as the old ones, we always have the option of going back and addressing that.
Exactly. And to follow up on that, Mr. Drakes, our CRC staff, if they could send us the data from the previous years, I know that Willie had went over how many complaints, and pretty much they were all resolved. If you could provide that to full council, so that everyone has the information ahead of time before our public forum.
Got that? Yes. All right.
Okay.
Ms. Johnson, do you have any comment?
Of course I do. Thank you.
I expected. Yeah, I can't see hands or anything. I thought I'd just call you. Yeah.
Thank you, I appreciate it. And thank you, Mr. Rackford, for the presentation. I was looking at the website, and CRC does amazing work. But one of the first things that I heard you say it today and also at the council meeting, you've been there for 41 years and you still get the question, what does CRC do? So when I hear that, I hear a problem. I hear that the community may not be aware of the wonderful work that you're doing. So the first question I would ask is, what can council do to help you so that you don't have to say that again? Is it a matter of more funding, more marketing? I mean, when you look at your services, the landlord-tenant mediation, Medicaid appeals, that's on there. I wasn't even aware of that. And even with the Fair Housing Act, I know that you said there might have been 6 source of income discrimination complaints where I literally heard from someone that contacted 100 landlords who said that they wouldn't accept Section 8. So I think that the gap is in the communication, and there's possibly a lot more complaints that aren't being communicated to the department. So I would be in favor of not waiting until we put this out there and to find out if there is a problem or a gap. I'm of the opinion that we know that there's a gap, which is why the public wanted us to create the enforcement. I would also want to have the same process for public accommodations or any of the classes. So I don't know why we're looking at this from a public accommodation perspective, and then are we looking at another process for natural hair, for pregnancy? I think we develop a process when we know there's a problem. So that's what I would be in favor of. And I also, if there's going to be fines associated with one class, I think that the fine should be associated with all of them across the board. So my first question is for Mr. Rackford: what can we do so that the city and the public knows more about your processes? This should be automatic, or not, if there's a problem, and people should know that there's a whole department and committee that's there to hear these issues, and that, there shouldn't be a question, what does your office do? This should be in front. So what's the first thing we can do? And then secondly, are we looking at the different classes for the processes to be different, or are we going to come up with a process for all complaints overall? Thank you.
First of all, thank you for your question. With regards to why we from time to time we have people who ask what is it that the community relations does, I think it goes back to something that you said earlier. It's because we're doing a whole lot of things, and folk just don't realize that from time to time. What we have discovered over the years is that while a lot of individuals in the community may not know what we do, whenever they have a need for our services, they have a way of finding us. Now, you had raised a question earlier about if we might need more budget If you're going to give me more budget, I'm not going to argue with you. I'll take that, and we'll put on a really nice public relations campaign. We have a newsletter, we have a website, we do all of the things that are necessary to get word about the work of the Community Relations Committee out into the community. And but we still have folk who ask, well, what is the Community Relations Committee and what is it that you do? But as I said, whenever people need the services, they have a way of actually finding us, either through looking at the website or through referral or just talking to a friend. The second part of your question regarding a separate process, I don't think we need to change the process. When you're investigating discrimination complaints, you're looking at it in one of two ways. You're looking to see if there's disparate treatment or if there's disparate impact. In most public accommodations complaints, it's going to be about disparate treatment. And the way that you investigate those, there's a universal way to investigate those, regardless of the basis for the discrimination. If the discrimination is based upon sexual orientation or if the discrimination is based upon race, I'm going to investigate those. The process for investigating both of those is going to be the same. The only difference is the basis for the discrimination.
Thank you. So it's my understanding that this committee was charged with looking at fines, with changing the process for the discrimination, universally, no matter what the issue is. So, so our current process, it's my understanding, and help me, Mr. Chair, if I'm misunderstanding, but we were charged with looking at fines. Are you saying that we wait and see if for the numbers before we discuss fines?
The question of fines was not put to us as a given. It was a question as to whether that's appropriate. And frankly, from some of the input I've received, it feels like a bad place to go. I think we have a mechanism that works right now. When you introduce the dimension of money fines, for one, that's a modification of our existing NDO process that's been in place and has worked all these years. And I know from talking to the mayor that I think we're better off sticking with what we have, adding these new classes, and then relying on the success of the existing process to resolve issues as they relate to the new classes.
Mr. Griggs, if I might add to your response, and Ms. Johnson, if that is okay by you, if you all were to add fine, let's say you added a $500 fine for violations of the ordinance and subsequent fines for, depending upon how long it takes. One of the things that you want to do in a discrimination investigation is if there's a violation of the law, you want to make sure that the complainant is made whole again. And so let's say in an employment case, you may have a person who is actually a victim of discrimination, and as a result of that discrimination, they've lost $15,000 or $20,000 with the company that they're working with. Through our conciliation process, we will attempt to make that person whole again to get what they should have gotten absent the discrimination. If you instituted the $500 fine, the company might say to you, we're guilty, we're going to pay the $500 fine, case closed, we're done. And that way the complainant does not get an opportunity to be made whole.
So that's damages rather than a penalty.
Yes.
So maybe the question is for the city attorney. Would there be an opportunity for both, for the claimant to be made whole as far as their salary, but also a punitive fine from the city for the violation of our ordinance?
So we would have access to the fine for violation of the ordinance, but we don't have any enabling authority to force, for instance, reinstatement, back pay, front pay. Those are all things that come out of the case law relating to the EEOC complaints, which are at 15 and above. We don't have that mechanism, the statutory mechanism that the EEOC has as it relates to employment. issues. As Mr. Ratchford said, part of the conciliation process would be to point out the deficit, if you will, of salary that occurred as a result of the discrimination. But we don't have that statutory mechanism to order front pay, back pay, as you would in EEOC claims.
Okay. So we don't have a statutory jurisdiction to force back pay. So it would be a part of the conciliation if we would recommend to the employer as part of the mediation the back pay or the lost wages, right? That would be that would be agreed upon. However, a fine would not. We have the jurisdiction to enforce a fine, right?
Yes, we have the authority to charge fines for violations of our ordinances. Yes.
So I see what you're saying, Mr. Ratchford. It could be looked at, I guess, both ways. If they say I'm not going to pay $15,000, I'm just going to pay the $500. Well, the claimant wouldn't agree upon that, and it could go to the next level. So I'm for the fines. I think that's what the residents and the public have asked for us. So that would be my position.
If I might, Ms. Johnson, if you had the situation where the respondent decided that they wanted to pay the fine, the complainant has no say over that. That's between the city and the complainant.
Right.
And
Right.
so the complainant would have to accept that if the city accepted the fine.
Right, but if I'm suing my employer and I'm owed, $5,000 in back pay, and I'm willing to mediate and accept that and not go to whatever that next level to court, and my employer says, no, I'm not paying you your back pay, I'm choosing to pay the fine, then I, as the complainant, don't have to accept the outcome, right?
They can't, well, the outcome is over at that point. If the city charges the fine, which stops the process, then the complainant doesn't have anything.
The complainant may not feel that a $500 fine is appropriate in the context of what was done to them, but they do not have the power to take the option of paying the fine off the table.
Yes.
So they could be in a position where they watch while the defendant pays the city the $500 and goes home. End of story. And I really think that the fact that we've had this for 50 years through all kinds of councils and so on for the prior existing classes is a strong indication that this is a system that works, and I don't know that we need to revisit our treatment of all of the prior existing classes by bringing up the subject of fines now that we've added new ones. I really feel it would be good if we could just work with our existing procedures. If you have somebody who is a repeat offender, that's going to escalate. They're going to find themselves in court. They're going to be subject to actions by the court, injunctions or other things. If you get a case where an unhappy employee makes a complaint and it's found to have a basis and the employer is cooperative and participates in the process and a reconciliation is achieved, that's probably sufficient. So I'm not sure the fines, that there is a question to which the fines are an answer.
Okay, and I only have one vote, and we can move on, that's fine. But,
All right, I've noted your suggestion, though, and we're not going to dispose of that when it comes time to make motions. If you want to make a motion, unfortunately, there are only 3 of us on this call. I would prefer to have a decision like that made with the presence of all of our members. So I don't know whether we're going to be able to fully resolve that, because I can tell you I wouldn't support fines. So you're not going to get 3 votes today. And in order to give you the benefit of a reasonable chance, we may take up the fines subsequently. We'll have to figure out how that works. But we do have that procedural problem right now of only having 3 people here. And
Mr. Driggs?
well,
yes.
can I finish? I'm sorry.
Go ahead.
Member Ajmer, I just want to follow up. can we ask Mr. Baker to clarify how that process would work, on how the fines would be implemented? That doesn't feel complete to me, that it would be an option, or if the employer chooses the fine versus the retribution for the employee. So legally, how could the fines be enforced? What that would look like? Would they be on top of of course they would be on top of the retribution. I'd like clarification on on what that would look like, Mr. Baker.
Okay, and do you want my, it's not so much a guess, but my thoughts now, or do you want us to take a look at it and come back to the next meeting? It's up to you.
It's up to you.
Yeah, well, I think it'd be better if we could just take a longer, deeper look at it. And I'd like to talk with you a little bit offline just to make sure that I've got some clarity on this. And if there's not a pressing need to have it right now, I'd love to bring it back to you at your next meeting.
Yeah, I think of it as, I guess, fines and restitution to a victim in a criminal charge. So how would that look civilly? There's a way for fines and repayment. So I'd like you to take a look at that if you can.
Okay, we got it down. Thank you.
And we'll keep the subject of fines open. I know another member of council has mentioned that as well, so I realize that's a question that we need to answer. The other thing I did want to ask the attorney, Ms. Johnson made reference to housing issues and source of income. What is the applicability of our ordinance to housing, if any?
What we've done, and what's in front of you is public accommodations, but what we did on the 9th is not related to housing.
That's my point. Housing is a whole different subject, and I think we expressly kind of carved it out when we were having these conversations. It's not that it has been neglected, but there are federal laws and all kinds of issues. I do think the question of source of income is still unanswered. I'm not sure that qualifies as such as a protected class, because we were talking about whether we should try to make it one, and we haven't yet taken council action on that. So I just want to be clear on the scope of what we did versus other issues that are addressed elsewhere.
Yes, and there is a separate source of income subcommittee meeting. In fact, I think we had our first meeting last week talking about that very issue that Ms. Johnson raised.
So, Mr. Ratcher, yes, go ahead.
I appreciate that. I know that that's being addressed in another committee. My point was that we heard Mr. Ratchford publicly say that there have been minimal source of income discrimination complaints, whereas I think anecdotally and realistically, this is really happening. It's just that people may not know the process, or he's not receiving the information. Because I have an example of someone that's called 100 landlords and not and hearing the word no, they don't accept the voucher. So, and they will be reporting that information to you, Mr. Ratchford, but that was my point. It wasn't about the issue of the source of income discrimination adjudication at this time.
So, Ms. Johnson, I'll mention that we did have a conversation with Ms. Weidman and considered the subject. It requires some care on our part to make sure that we defend the legitimate interests of landlords and properly identify those who actually discriminate. And that's going to be a separate topic for us. And in that context, when we've resolved where we stand on it, the method for filing a complaint can be made better known. I agree with you that there are many instances where the vouchers, for example, are denied. We know that's a problem. I think some of it rests with the, what is the new name, Inlivian? Inlivian, to kind of ensure that the support they provide is accepted by landlords. But again, it's a topic that doesn't really fall within the scope of what we're trying to do here as a result of the action the council took recently.
Great. I have a follow-up question for Mr. Ratchford. So are you concerned that if we were to implement fines and penalties, would that negatively impact the resolution or the reconciliation process?
I think that is a possibility in the context that I discussed earlier, and that if the respondents know that they're guilty, but they see an opportunity to get out of the situation by paying a $500 fine, then that's problematic for me. The other issue, or the other thing that might make the process burdensome with fines is when do you actually make the fine? So if someone files a complaint, and if it takes us 50 to 100 days to investigate, especially those complex complaints, you can't make that fine until we have determined that there has been a violation of the ordinance. And the complainant may disagree with our findings, which and force us to end up sending this matter to the city attorney's office, and the city attorney's office may have to end up going to court to enforce the fine if the respondent decides not to be cooperative.
I understand. So, in certain instances, folks would not want to, there is no incentive for them to resolve the situation if they can just get away by paying fines or penalties of some sort.
So I think you've got to ask the question, what may be best for the person who is a victim of discrimination? Is it fines where the money might end up in the coffers of the city? Or
Right.
do you do conciliation? Now, with conciliation, and the best example I can give you all is we also enforce the city's fair housing law, and we use conciliation and mediation as a part of that process also. And it's mandatory that we attempt conciliation throughout the investigative process. And with those conciliations and cases that we've conciliated or mediated successfully in the past, we have gotten negotiated settlement agreements where the complainant has received as little as $500 and as much as $100,000.
Got it. So, yeah, I don't think there is one solution for all where you apply 500 or 100 or 250 or $1,000 fine across the board, because it's going to really depend on the situation. And I guess at the end of the day, what is our goal, right? Is our goal is to make person whole, or is our goal is to increase city coffers by penalizing or increasing fines? And at the end of the day, I think that's the question we got to ask council. What is our goal? And I would say, for me, I would like to see person made whole again, because of the.
Ms. Ajmera, I would submit that our goal is to discourage people from discriminating. First
Yes,
and
but
foremost.
at the end of the day, if there is an instance where there is discrimination, and we have seen that has happened in the past where our staff has been able to reconcile. So I guess our goal should be, is to discourage, but is it really realistic, 100%? Well, I don't know. I don't think so from what we have seen in the past, where Mr. Ratchford and his team has been successful resolving and reconciliating many of these claims. So I guess I think that's the question we got to ask. What is really important? And for me, it is we got to make the person whole again.
If I might help, the goal of the Community Relations Committee in investigating these complaints in the past has been twofold. We don't see it as either or, we see it as both and. And so we want to make sure that the discrimination stops and goes away and doesn't happen anymore. But at the same time, if a person has been a victim of discrimination and the ordinance or the law has been violated, we also want to make sure that the person is whole. So it is a both and not necessarily an either or.
Got it. Thank you, Mr. Ratchford, for your work.
Thank you.
So you hadn't actually finished yet. Why don't we?
We're not done yet.
Yeah, I know. This is ironic. I was complaining in TAP yesterday about the fact that we weren't able to finish on time, and we're kind of way off. But this is a good discussion, and that's the important thing. So carry on.
Okay, next slide, please. This is very quick. The NDO also covers passenger vehicles for hire and commercial non-discrimination procurement. And right now, with regards to passenger vehicles for hire, those complaints are handled through the PVH board, and we would recommend that they continue that process of enforcement and that not be in the hands of the staff of the Community Relations Committee. And regarding procurement, which really has to do with contracts, whenever someone signs a contract with the city, someone in procurement has to go over that contract to make sure that the language that's required by the NDO is included in that contract. And I would suggest that the procurement people continue that also. If not, that will require all city contracts coming through CRC to be looked at just to make sure that the language is there. And I'm not sure if that's efficient or effective. Next slide, please. Employment protections. We are proposing that a complaint investigation process for employment would align up with what we do with regards to fair housing investigations. And we have tons of experience doing this. The city of Charlotte has had a fair housing ordinance since 1980, so we have 41 years of experience actually investigating discrimination in housing. And what we are proposing is a process that, if you can go to the next slide, that is very similar to what we do with fair housing. And again, I would start this off by saying there have been some concerns that folk would file frivolous complaints. Well, no, we would actually take it through that jurisdictional process, again, because we want to make sure that complaints, one, are not frivolous. And at the same time, we recognize that our duty as staff of community relations is not only to protect the rights of the citizens who feel that they have been victims of discrimination, but also to protect the rights of respondents and employers who may be falsely accused. So we have that balance. We're a third neutral party who is only concerned about the facts and that everyone is treated fairly and rightly under the law. And so we're looking at a process that aligns with fair housing, and we would receive the complaint, do an investigation. After that investigation, we make a determination. And as that investigation is going on, we would concurrently be attempting conciliation. And if conciliation is successful, we could stop the investigation process as in fair housing or with public accommodations and close the case administratively without making a finding of fact. But in the end, if discrimination is determined and we are unable to conciliate through that process, at the end of that process, this too would then be referred to the city attorney's office for appropriate action.
So the question here is whether there is a reason that the process that exists right now doesn't work or needs to be modified in the context of our new employment protection. I mean, the question for the committee is, or do we take the recommendation of Mr. Ratchford and use what we already know and what already works for this new situation, the employment protection? And again, my inclination is absolutely to follow your suggestion and take something that is tried and true and not reinvent it. But again, the question is, does anybody think that there is some way in which this doesn't work for the new situation of employment? No hands up? Okay. Good. So you've spelled that out for us. I guess, are we at questions now, Mr. Ratchford?
Yes, that is correct.
We've had quite an extended discussion, and I guess the question now for the committee is there an action that we can take today, a recommendation that we can make to the full council today? And I'm thinking here about the sort of timeline, the effectiveness of the public accommodations portion. It starts October 1st. So it would be good for us to get back to the full council with a recommendation on which the council can act so that we have something in place on the effective date. And I would suggest that we need a motion to the effect of actually kind of following the recommendations of Mr. Ratchford and the committee as to the operation or the enforcement of our new ordinance. I mean, recognizing that the issue of fines is still open. But can we make a first step and just say that this committee recommends to full council that we use the procedures applicable to existing protected classes for the new protected classes?
But implementing the fines would be a different process.
Well, I think what we would have to do is we would have to get the city attorney's input on that. We wouldn't close the door on the subject, and we would still have time to hear from the city attorney. It could come up in the full council meeting, or it could come back to this committee. So we are not excluding the possibility of fines. I would just like for us to be able to take an action today that puts in place an understanding in all other respects about how the new ordinance will work. So again, I'm suggesting that we have a motion today that suggests that the administration and enforcement of the new protected classes will be the same as for existing protected classes, with the proviso that we will discuss further the subject of fines.
Okay. And then, are you comfortable doing that with the three of us, or do you want to wait for the full committee?
If the three of us can agree on that, there are three of us, and that's a quorum, and we can do it today.
Okay. And are we going to request more in the budget for CRC also?
With regards to public relations, I would think not. As I said, while we have people to ask about what is it that the Community Relations Committee does, whenever anyone's in this community needs our services, they always seem to find us. And I don't even know if it's appropriate to even bring this up, but obviously to take on 7 additional protected classes is going to, might at some point down the road require additional staff. As I recall, we were advised that there are, with regards to employment, that there are 13,400 small employers in this community. With a 1% complaint rate, that equates to 134 complaints a year. And if it takes anywhere from 50 to 100 hours to investigate those complaints, that equates to 3 to 4 full-time positions. And I'm not saying that we should get 3 or 4 full-time positions, but at some point we need to start thinking about what additional staff might look like if we are in fact going to do this work.
So, Ms. Johnson, a better time to be talking about that would be during our budget process anyway.
Right.
And rather than ask Mr. Bergman if he's got, some extra dollars in his pocket, would you be okay for us to do this now, see what our experience is, and then take it up as a line item conversation when we do our next budget?
Absolutely. I know that I was kidding. I trust Mr. Jones that he would work that out. So yes, I can agree. I would support that motion.
All right.
As long as the door open for the fines discussion. If we start with this process, then I support the motion. I second them. Or do you need me to make the motion or second the motion?
So can the chair make a motion?
No. Yes.
Yeah. So again, I would offer the motion that our administration and enforcement of the NDO, the expanded NDO, follow the model of the existing process, provided that we will take up the subject of fines and of the budget impact at a later time.
I second.
Okay. So Ms. Ajmira?
Yes, I support.
Ms. Johnson?
Yes.
And I'm a yes, so we can do that. Good. I didn't know all of the things you just told us. Amazing. After we've known each other for so long, and I've been in this job for a long time, that was a very informative presentation. Thank you. So we now are in the situation where we have 20 minutes left and 2 more topics. At this point, what is the time sensitivity of the virtual meetings subject? Could we take that up at a later meeting?
Yes, sir. Yes, sir, I believe so. I think that the emergency order that is allowing for virtual meetings is, given where the community's at with the Delta variant and other things, I think that it would be appropriate.
That's my feeling too. What we need to talk about here is what the situation will be when the emergency order is lifted. Given that doesn't seem to be a near-term prospect, and in particular, colleagues, you'll remember this was sent back to us because there was a question about the provision that says you could participate virtually in meetings if you were sick or if you had a family emergency. And I think the mayor in particular wanted us to kind of be a little more thoughtful about how that works. But I don't believe we need to resolve that today. So what I would like to suggest is that we invite the internal auditor to speak to us, and we spend the rest of our time on internal audit questions.
I do have one question.
Yes.
Do we know how long the government building will be closed? Is it indefinitely?
So there is not a set expiration on it. What I would say is the intention is, well, right now the intention would be that once the County Board of Health order goes into effect, we would continue monitoring the situation with the building, CMGC, based on the existence or continued existence of the County Board of Health order. I believe the County Board of Health order expires not on a date specific, but based on community metrics related to positivity rates of new cases of COVID.
Okay, thank you. And so, Mr. Chair, I just wanted to clarify, when I made the motion for council meetings virtually indefinitely, that was kind of the basis. It's not irresponsibly or anything like that, but because there's no defined or a definitive date. So I'm willing, I think it's a good idea that we just table the issue for now.
Mr. Driggs
okay.
and Ms. Johnson, if I may just clarify. So again, I think what Brent is speaking to is the local public health order. Our virtual meetings authority, again, is based on the statewide declaration of emergency, not
The critical,
So I just want-
the critical determinant as to when we need this is when the state of emergency ends, but I think we're assuming reasonably that will remain in effect for as long as our local ordinance. But you're right, the defining moment. And I would call it until further notice rather than indefinitely. It basically means we don't know. We're awaiting events, and I think it will be apparent when it's time to open the building that we can do so. So let us now get to the internal audit. And I don't think you need to do it in 90 seconds, but if you can do it in 5 minutes, that's good.
I believe I can. Thank you, and good morning, Mr. Chairman and council members.
This is Mr. McDowell.
Greg
our
McDowell, City Auditor.
Thank you.
We issue about 10 to 15 audit reports a year, and all of those reports can be found online. I think our total is up to over 80 audit reports. And we come to you every once in a while to update you on our audit plans. Given the time, I'll focus on the future with just a little look back that occasionally we come to you and talk to you about a specific audit. And you can go ahead and go to page 2 there. And so a year ago or so, we talked to you about capital procurement, capital management, and we continue to do follow-up on that, and we are satisfied with the actions that staff is taking. And if we weren't, we'd be talking to the city manager, we'd be talking to you. And so we actually update our audit plan. We publish a status online every month. I have not done that in the last month, and I have not put the current audit plan online until I had a chance to brief you, because I want you to be aware of a couple specific things that we plan to do, and I've already done really since June 30th. So on this first page, you can see that we had 8 audits, first and second page, 8 audits that were in progress June 30th. And we already completed 2 of those and issued those and put them online. That would be the CATS Department of Procurement And on the next page, it was a cost allocation plan. So those are done and online. Back to that first page of audits, the financial accounting controls at the bottom of the first page will be issued and put online later this week. We mentioned the CARES Act fund distributions, and that report is being completed. When I wrote this in June 30th, I thought it'd be done in August. I would now project September for that. On the second page, after cost allocation plan, we have 3 other audits that we plan to have issued in October. It's an INT report, a couple of construction projects. So in addition to following up on the construction management that we did substantially last year, we're doing additional construction audits, and these are 2 of them. By the end of November, we'll issue a CATS-specific COSO review. So on the previous page, we talked about a follow-up to a Grant Thornton study that was done 3 years ago, and that report will be coming out soon. And so COSO is just a framework for studying internal audits. The Committee of Sponsoring Organizations, Treadway Commission, it's been around for decades, literally, and auditors still use that. And so we did it at a citywide basis, and now we're planning to do, or actually have in progress, a CATS-specific internal audit review. We list a couple annual audits, and these are fairly standard. Vice Impress and Revenue Collections. We'll continue doing that every year. On page 3, we mentioned some specific follow-ups that we'll be doing or considering. Our audit plan is actually a 2-year plan, so we list a dozen audits or initiatives that we might undertake in the next 2 years, and actually 3 of them have already been announced. And those 3 are at the 2 on the bottom of page 3, the CATS advertising revenue and private developer funds through CDOT. And on the next page in the middle, there's a housing and neighborhood services audit. But I draw your attention to the top of page 4, where we'll be formally announcing an audit of police body-worn camera. And so I want to point out that the police chief actually requested this audit from internal audit. And we've been working with him to develop what we might accomplish, focusing on internal controls, looking at their policy, training materials, their hardware, and the data that's generated. But I want to make sure you understand that we understand that by law, internal auditors cannot review the body-worn camera recordings. And so that's probably the question you might hear and I might hear. What are auditors doing? And we believe we can look at whether the controls are designed adequately, and we can look at a lot of data. You may be aware that officers make thousands upon thousands of recordings, and we want to make sure that they're doing tests properly and they're docking their cameras properly, and that supervisors are reviewing the recordings for training purposes and otherwise. Obviously, there are a certain classification of recordings that will always get reviewed, but on a sample basis, supervisors review officers' recordings quite regularly. In fact, over 1,000 recordings a month are reviewed at the supervisor level. And we'll make sure that that's being done in a reasonable fashion, that it's being spread among all the divisions and all the officers get that opportunity. Sometimes they raise concerns. Sometimes it's as simple as a uniform issue or using a word that we don't want our officers to use. Tattoo showing is supposed to be covered up with a uniform. And sometimes it's more serious than that. But just the fact that they have concerns does not necessarily mean a big problem. But we'll be looking at the data and making sure they're following their own policies. We list a few other categories of IT and internal controls and some other commitments we have, but rather than go into detail there, I thought I'd stop there and take questions if you have any.
That was impressive. Thank you.
Does I have questions?
Yes, go ahead.
Yes, so thank you, Mr. McDowell, for this presentation. A couple of questions. So are these all part of standard audits, or I guess how do you determine which audits to do every year, or are these required by the law?
No, there's nothing really that's required by law. We use our professional judgment. We do a risk assessment. Sitting at my side, Tina Adams, Deputy City Auditor, took a staff member and visited with every single department and asked for their input. We pay attention. We look at what other cities are doing. For example, the body-worn camera audit, we saw another city where the city said, hey, you got a great policy. And, oh, your policy says you're going to be reviewing, doing supervisory review. And then the audit found they weren't doing it. So when we see, again, we look at other audits, we talk to all the departments, we pay attention to what is a concern of council. You know, we actually pay attention to what we think is important. We try to touch on all departments over a period of years. A couple of years ago, I said we're going to focus on construction, internal controls, and computer security. And so you'll see that we continue to touch on those, but also, you know, when new things come up, we didn't ask permission necessarily to audit CARES, the CARES package. We said, when you design a new program and put money out there and start giving grants to thousands upon thousands of people, there's a risk. And so we identified that risk, and it wasn't in the original audit plan when we came to you last year, but we said we need to look at this. And so the short answer to your question is there's nothing that legally that says what we have to audit, but we ask a lot of people's opinions and then apply our professional judgment, which includes Tina Adams and myself have over 20 years here with the city.
Well, I appreciate the expertise that you bring to the table. Could department head request an audit of their division if they have specific concerns?
Absolutely.
I know that Chief had requested audit of body-worn camera, and I know that your team is going to do that. So could individual department heads do that as well?
They could, and they do. And sometimes we just have a category, for example, INT or construction, and we'll work with departments to determine where best we can deploy our resources. That doesn't mean they tell us what to do. That means that if someone suggests a problem and they want to make sure that the controls are adequate, then that raises it up on our level where certainly we'll take a look at that.
All right. So I was trying to follow the report that you have up on the slide here. So the audit was done for our CARES funding. Would you please send us that report? I'm interested in seeing that, especially with the large sum of money and thousands of payments that went out.
So the CARES report should be issued in September, but I can tell you that we focused on the small business recovery, the $50 million fund, and the $20 million housing fund. And I can tell you that, again, the report's not issued, but the city followed federal guidelines. Absolutely followed federal guidelines. So the audit report will say that specifically in the conclusion. It'll also say council set up some additional guidelines of how they wanted that money to be handled. And so don't be surprised, auditors might have found a handful, I'm talking out of thousands of grants that were given, a handful that perhaps weren't handled exactly according to the terms that you set up. So for example, there have already been literally 2 or 3 people who received grants of $10,000, and upon a review, we determined that they should return those funds, and they have. But the conclusion of our audit is it was very well designed. In a short period of time, we put money into the hands of the people that you designated, that you wanted to have. But again, deciding what to audit, we did a risk assessment, and we said, these are the funds we're going to choose, the housing and the business, the small business recovery, because that's where we saw the risk. We didn't see as much risk, for example, with the airport funds. A large amount of money to the airport. But the external auditors will be looking at that. The FAA will be looking at that. And I have some experience with the airport, and we felt that, again, where do we put our resources? We put it in the areas that we think are a higher risk.
Thank you. Just to follow up on that, for all the CARES dollars, is there a federal requirement, or would there be an audit, external audit, that would have to be done for this CARES dollars?
Well, the external auditors are also looking at it. But in fact, we've spoken with them about what their effort would be, and I see right behind me is your CFO who could answer any specific questions, perhaps about what the external auditors are doing. Sometimes I do things that external auditors do, but we take a different slice. So we did an investment audit one time, and we said, well, the external auditors look at our investments, and I did it, took a little different angle on it, and so sometimes people think they have enough auditing, and other times we try to find ways to give them extra attention.
Got it. No, I think this is a great way for accountability to ensure the dollars are spent the way council had laid out in their framework. Thank you, Mr. McDowell, and your team for an excellent job.
Thank you, appreciate it. And like I said, our audit reports are online. All the audits we set out to do last year, the status is online and updated monthly. And so from that, you can actually get links to the individual reports or see the results of each audit in brief.
Thank you. And I'm guessing that CMPD would like that audit as a means of demonstrating that they feel confident about their handling of the body-worn cameras. So we'll see what your conclusions are.
If I may just say, sometimes auditors are not welcomed. And
Right.
so when we started having this conversation, and I was telling the chief what we might do, I said, don't be overly concerned about internal auditors. We don't have a mindset that we have to find something. And the chief and one of the majors that we spoke with said, oh, I hope you find something. We think we're pretty good, but we can always get better. Now, that's, as an internal auditor, that's just music to my ears to have someone say, we want you to look at it. We're not going to tell you what you have to do. We're open. Come in and do whatever you can. And if you can help us improve the program, we're very open to it. I mean, I've actually had people say, I'll be disappointed if you don't come up with something.
No, we appreciate your quality control function, and I think it's important for us to be able to demonstrate to the public that we do have an internal process for making sure, to ensuring the integrity of the work we do. I'll ask you a very general question, and again, we're a little short on time, but are there any outstanding problems, issues that you've discovered that we're still resolving or that you're concerned about in the broadest sense? Like among your audits, have you come across things that still need to be resolved? And you did tell us at one point that you found some issues about how the capital budgeting was done. And I think we're still engaged in a process of fully addressing those. Anything else like that?
There's more to be done, but we're making progress. For example, following up on the Grant Thornton COSO review from 3 years ago, we said we haven't really made as much progress as we should have. And I have the CFO's agreement with me, I'm pointing, she's still behind me, that more is being done. And they're organized to address them more specifically. And so, sure, when I look at CATS procurement or the capital program, or we revisit some things, auditors, we always want you to move quickly. But I don't have any complaints. I don't have any, we're getting the attention, management gives us the attention, and we recognize the competing interests for taking actions. And so we will definitely highlight any issues that need, closer attention or more effort.
So we can share with the public that in your opinion, the city is generally well run?
Absolutely, absolutely.
All right. Any other questions from committee? Ms. Johnson?
Thank you. That was sort of my question. I appreciate the presentation. Thank you, Mr. McDowell. Just to clarify, your department audits processes and financial, correct?
It includes almost everything you could think of. If someone asks,
Operational and financial.
yes, operational and financial. If someone says, does the internal auditor have an opinion about X, we can come up with an opinion from our perspective.
Is that the answer you wanted?
Yes, thank you.
All right.
Thank you.
Appreciate both of you. My sister's name is Tina, so it's nice to see you with us today. And if there is no other business, I will entertain a motion to adjourn. All in favor, get up and walk out.
Motion to adjourn.
Thanks, everybody.